The marble floors of the Supreme Court echoed faintly with every shifting foot, but otherwise, the chamber was frozen in tense silence. Every seat was filled, judges cloaked in black robes, aides clutching notes, journalists armed with pens and cameras, and behind them, the murmuring tide of public anticipation. At the center of it all stood Elon Musk, upright at the petitioner's lectern, framed by history and controversy. His expression was unreadable, his posture steady. The world watched through courtroom sketches, breaking headlines, and live streams masked in legality. Justice Amy Coney Barrett leaned forward slightly, her eyes sharp, voice piercing the stillness with calculated precision. "Mr. Musk," she began, her tone clipped and cool, "you claim your satellite network operates beyond traditional regulatory frameworks. Yet here you are, seeking protection under American law." A pause. She continued, her voice growing bolder. "Is this not an exercise in privilege? Wanting the benefits of legal protection without the burden of legal accountability? One system for billionaires, another for the public." There it was, the first public jab. Deliberate. Framing. The courtroom stiffened. A subtle, collective inhale. Reporters looked up. Pins scratched faster. Musk did not blink. He did not glance at his notes. He stood calmly, hands resting on the polished wood, his face lit by the soft glare of courtroom lights. He looked not like a man under fire, but like someone waiting patiently for the wind to change. And the wind was about to turn. The silence that followed Justice Barrett's pointed challenge was heavy, almost theatrical. But Elon Musk remained composed, his gaze steady beneath the weight of the question. He leaned slightly forward, clearing his throat, not to stall, but to steady the room. "Justice Barrett," he began, his voice smooth and deliberate, with deep respect, "that framing fundamentally misunderstands what is at stake here." A subtle ripple moved through the gallery. Not defiance. Precision. "This is not about special privilege," Musk continued, his tone calm but gaining traction. "It is about legal infrastructure attempting to govern interplanetary tools with terrestrial logic." He held up a printed page, dense, stamped, and highlighted. "This," he said, "is a memo from the FCC's own advisory board. It admits current laws, written in 1934, fail to cover satellite networks that operate beyond Earth's orbit." Justice Barrett's brow furrowed slightly. It was not embarrassment. It was surprise. Musk pressed on. "We are not evading regulation. We are asking the nation's highest legal body to recognize that a communications framework built for radio towers and rotary phones cannot be forcibly stretched to cover orbital networks reaching villages in the Congo or refugee camps in Syria." The room shifted again. What had started as a prosecutorial moment had transformed into a policy reckoning. Even the justices known for restraint began taking notes. Justice Kagan leaned forward, visibly intrigued. In that moment, Elon Musk was no longer a billionaire on trial. He was a man redefining the legal structure of the 21st century, one sentence at a time. Justice Amy Coney Barrett sat motionless, but her mind was not still. Beneath the polished composure and piercing gaze, a storm of calculation was unfolding. She was not accustomed to losing control of a courtroom narrative, especially not to someone outside the legal profession. Her question had been deliberate, shaped to corner, to reveal, to reduce Elon Musk to yet another self-interested mogul cloaked in the language of innovation. But his answer, his document, had shifted the entire gravity of the moment. Her fingers tapped once, softly, on the bench. She knew the memo he referenced. She had skimmed it in her preparatory briefs, but dismissed it as informal, a technical advisory. Now, it had become Exhibit A in a much larger trial, not just of Starlink, but of legal time itself. She glanced briefly at Chief Justice Roberts, who offered nothing. Gorsuch scribbled something quickly. Kagan stared ahead, lips pursed. Even Sotomayor, skeptical and sharp, seemed engaged. Barrett hated when arguments turned rhetorical instead of legal, but Musk had walked a careful line. He had not dismissed the court. He had invited it to evolve. Her instincts fought each other. One said, "Press harder." The other whispered, "This man might be right." Still, she was not ready to yield. Not yet. Her next question would be critical. It would determine whether she regained control of the room or handed Musk the microphone for a revolution in law. A moment passed. Then she leaned forward, voice clipped, eyes narrowing. "Mr. Musk, are you suggesting the Constitution is outdated?" Elon Musk did not flinch. Justice Barrett's question cut like ice. Are you suggesting the Constitution is outdated? He raised his head slowly, locking eyes with the bench. His voice remained calm, measured, almost reverent. No, Your Honor, he said, his tone sharpened with clarity. The Constitution is not outdated, but our interpretations can be. The courtroom froze again. Musk stepped closer to the lectern, his silhouette framed by the weight of history. When electricity was discovered, we did not regulate it like whale oil. When airplanes were invented, we did not apply wagon laws to flight. We evolved. He paused, then added, I'm not asking this court to abandon the law. I'm asking it to recognize when law, as currently applied, becomes a barrier not to chaos, but to human progress. He turned, gesturing to the gallery. These people came to see a billionaire get scolded. But what we're discussing today affects farmers in Nebraska, medics in the Amazon, children learning in refugee camps, who only have access to education because of satellite internet. He reached down and held up a 1934 bound document, the Communications Act. This is the foundation being used to regulate technologies that orbit the Earth. We've gone from Morse code to quantum encryption, but this is still the manual. Barrett blinked. For the first time, the court began to listen differently, not as judges weighing a corporate plea, but as guardians of a legal framework being asked, respectfully, to evolve. What happened next was subtle, but seismic. Justice Neil Gorsuch leaned forward, his fingers tinted thoughtfully. Mr. Musk, he said, you argue that regulatory frameworks must evolve. But is that not Congress's job, not ours? Musk nodded. Exactly, Justice Gorsuch. That is the heart of this case. A murmur spread in the gallery. The tide was turning. He continued, but the problem arises when federal agencies, not Congress, try to stretch their mandates to cover new domains they were never authorized to govern. This is not legislation. It is improvisation. Gorsuch exchanged a glance with Justice Kavanaugh, who raised an eyebrow in interest. Even Justice Ketanji Brown Jackson, typically reserved, shifted slightly in her chair. Across the bench, Barrett's composure remained steady, but her tone softened as she spoke again. You claim this is improvisation. But is it not also caution? Precaution for the public good. Musk's reply was swift. Precaution becomes overreach when it stifles the very innovation that could solve global problems. Regulation is necessary. But when those regulations are outdated, we are punishing solutions with red tape. He looked directly at Barrett. That's not caution. That's fear masquerading as policy. The courtroom inhaled sharply. One by one, the justices' expressions began to change. Doubt surfaced. Curiosity overtook skepticism. The courtroom, which had begun as Barrett's stage, was slowly becoming Musk's arena. Elon Musk took a calm breath, reached down, and lifted a manila folder from his table. If I may, Your Honors, he said, holding it up for the clerk to collect, these are documents obtained through a recent FOIA request. They were not part of the original brief because they were released just last month. Justice Amy Coney Barrett raised an eyebrow. We cannot admit new evidence at this stage. I understand, Musk replied. But these are public records, memos, transcripts, and internal emails from the FCC's Technical Advisory Committee. They show something troubling. The agency's own experts admitted they lacked clear jurisdiction over orbital networks. Yet enforcement proceeded anyway. Justice Elena Kagan leaned forward. Are you saying the FCC deliberately ignored their own legal ambiguity? Musk didn't flinch. Yes. They acknowledged the legal gray zone, then rushed forward anyway, fearing that delay would erode their power. Gasps whispered through the courtroom. Reporters scrambled to write. The live feed flickered with urgency across social media platforms. Justice Gorsuch picked up one memo. This line here, we must assert jurisdiction now, or lose it entirely. This is from the FCC director? Musk nodded. Correct. That sentence defines everything wrong with this case. Suddenly, the courtroom dynamic shifted again. Barrett's original challenge had opened a door, and Musk had walked right through it, armed not just with confidence, but with damning institutional insight. The story was no longer Musk versus regulation. It was Musk versus the misuse of authority. Justice Amy Coney Barrett, known for her precision and poise, adjusted her posture. The bombshell from Musk had knocked the rhythm of the hearing off balance. She leaned back into the microphone, her voice still firm but now measured, as if regaining footing. Mr. Musk, she said, even if we accept that the FCC may have overreached, your companies have still benefited immensely from government contracts, subsidies, and public infrastructure. Is it not fair to say you owe compliance with the system that supported you? The tone was sharp, but the pivot was clear: redirect the issue back to accountability. But Musk, unshaken, met her gaze with quiet steel. Justice Barrett, I agree. Public-private cooperation is vital. SpaceX would not be where it is without NASA, and Tesla has thrived under emissions incentives. I do not deny that. He paused just long enough. But acknowledging cooperation does not mean accepting regulatory overreach. We followed every rule that actually applies. What we challenge is the backward application of 1930s laws to orbital, decentralized, 21st-century technologies. He stepped slightly closer to the microphone. Justice Barrett, when cars were invented, we did not apply laws made for horses. When planes came, we did not govern them with train conduct codes. Technology evolves. Law must too. Barrett's expression didn't betray emotion, but her fingers tapped once on her bench. Musk had just reframed the debate again, from billionaire defiance to civic responsibility. And for the first time, many in the gallery were nodding in agreement. The energy in the chamber shifted like a tide turning. Justice Neil Gorsuch, typically reserved, leaned forward with visible interest. His voice, steady but probing, broke the pause. Mr. Musk, he said, the FCC's jurisdiction has always extended to wire and radio communications. Are you suggesting their authority ends at the Carmon line? Musk smiled subtly, not smug, but prepared. Justice Gorsuch, I am suggesting that Congress never authorized terrestrial agencies to govern orbital systems with global reach. And the FCC's own internal technical panel, documents obtained via FOIA, concluded as much. They warned the agency was applying laws beyond their intended scope. A quiet stir rippled through the gallery. Justice Elena Kagan chimed in, her eyes narrowing with interest. In these internal communications, you claim they were ignored in favor of preserving regulatory control? Yes, Musk replied. They feared that inaction would cede authority to international competitors, so they acted preemptively, without legislative mandate. The courtroom held its breath. This was no longer just about SpaceX or Starlink. It was now about government power, boundaries, and institutional integrity. Musk's tone remained respectful, but passionate. We are not anti-regulation. We are pro-modernization. The laws we follow must be fit for the realities we face. Justice Sotomayor nodded faintly. From the back rows, reporters tapped frantically. The story was evolving. The man who had walked in as a perceived antagonist was now challenging the very assumptions undergirding outdated governance. Even skeptics in the room felt it. The narrative was changing. Justice Barrett leaned back in her chair, briefly folding her hands, before striking again, not with hostility this time, but with concern. Her voice lowered, deliberate, and heavier with moral weight. Mr. Musk, she began, while your arguments on legal frameworks may hold water, they raise a deeper ethical question. What happens in the regulatory vacuum you describe? Who protects the public while Congress takes its time catching up? The question was laced with something more than legal scrutiny. It carried the implication of responsibility, even consequence. The gallery went still again. Musk stepped forward slightly, his expression softening but not retreating. That is a fair concern, Justice Barrett, he replied. And that is why we have not waited idly in this so-called vacuum. He raised a document, Starlink's internal policy framework. We voluntarily adopted the strictest cybersecurity protocols from NATO partners, instituted independent audits with former defense officials, and created an oversight board that includes former FTC and FCC members. He let it sink in. This is not about escaping oversight. It is about creating relevant oversight. Barrett nodded slowly, the edge in her tone dulled, but not her intellect. So you're saying innovation must not pause for outdated laws, but neither can it operate without guardrails? Precisely, Musk replied. But those guardrails must be built for the road ahead, not for paths long abandoned. A murmur of agreement stirred among legal scholars in the gallery. Even Barrett's own expression betrayed a shift, not surrender, but reflection. The courtroom was no longer a battleground. It was becoming a blueprint for the future. Just as the tension softened between Musk and Barrett, a new voice entered the fray, deep, composed, and commanding. Justice Clarence Thomas leaned slightly forward, his fingers steepled as he addressed the Solicitor General, not Elon Musk. Counsel, he said, how do you reconcile the FCC's decision to assert authority over orbital infrastructure with the major questions doctrine? The courtroom shifted. The doctrine Thomas referred to had recently gained traction, emphasizing that federal agencies must not make sweeping decisions on major economic or political issues without clear congressional authorization. The Solicitor General hesitated. Justice Thomas, we believe that the FCC's authority over communications, whether by wire, radio, or orbit, falls within its statutory jurisdiction. But this, Thomas interjected, is not a mere extension of authority. This is a technological leap unimagined by the drafters of the Communications Act of 1934. He turned toward Musk. Mr. Musk, you suggest that this is an attempt to stretch existing laws beyond recognition. What, then, is the appropriate remedy? Musk did not miss a beat. Legislation, Justice Thomas. Clear, democratically authorized legislation that reflects 21st century realities, not regulatory improvisation based on laws designed for terrestrial radio towers. A soft ripple of agreement moved through the court. Even some of the liberal justices leaned in. Thomas had reframed the argument from policy to constitutional principle. Barrett's earlier challenge now met with legal reinforcement from an ideological counterpart. The lines were blurring. The case was no longer Musk versus Barrett. It was law versus time. When Elon Musk returned to the lectern, the atmosphere in the Supreme Court had shifted from confrontation to contemplation. No longer under fire, he now stood in a position of strength, an unlikely architect of legal evolution. He began without notes, his voice calm but resolute. Your Honors, we are not here to dismantle regulation. We are here to refine it. All eyes were on him. Even Justice Barrett, once skeptical, leaned in slightly. Our legal system was never meant to be static, Musk continued. It was built with the foresight to adapt. The founders could not have predicted the internet, let alone orbital communication networks. He gestured subtly toward the ceiling, invoking the invisible constellation of Starlink satellites orbiting above. And yet, he said, we are attempting to regulate them with statutes written before color television. The justices listened silently as he laid out a vision for responsive, adaptive regulation, one that welcomed innovation but safeguarded the public through transparency and oversight. Regulation must be proactive, not punitive. It must be built with technological fluency, not institutional inertia. He paused for a breath, then looked at each justice. We are asking this court to send a message that America does not fear innovation, it leads it. For a brief moment, there was no division, no liberal or conservative bench, no tech billionaire and judge, just a shared understanding that something larger was at stake. Not just a case, but a precedent. Not just a decision, but a direction. As the session adjourned, the buzz inside the Supreme Court chamber spilled onto the marble steps outside. The nation's top legal minds, media correspondents, and tech observers erupted into conversation. Within moments, news outlets pushed breaking headlines. Musk shifts Supreme Court debate. Justice Barrett confronted, then convinced. Clips of the courtroom exchange flooded social media. Musk's line, regulation must evolve with the technology it seeks to govern, trended globally. Legal analysts called it one of the most pivotal Supreme Court moments of the decade. What had begun as a setup for public embarrassment was now being reframed. Musk, previously cast as a regulatory rebel, was being praised as a rational visionary advocating for modernization. Justice Barrett, once the hardliner, was seen as a thoughtful jurist willing to evolve her position in the face of reasoned argument. Cable news debates erupted. Was this the beginning of a new era of tech law collaboration? Was this Musk's most strategic public pivot yet? Even critics softened. I never thought I'd agree with Musk on regulatory policy, one well-known technology ethicist tweeted, but this was compelling. At campuses and law firms nationwide, the exchange was dissected not just for its outcome, but for what it revealed. An entrepreneur willing to play within the system to help rewrite the rules. Musk had not just won the moment, he had reframed the narrative. And perhaps more importantly, he had pulled America into a serious conversation about the future of innovation and law. 3 months after the arguments, anticipation reached a fever pitch. Then, on a clear Thursday morning, the Supreme Court issued its ruling in Starlink Communications versus Federal Communications Commission. The decision landed like a thunderclap across the nation, a 7-2 majority opinion in favor of Starlink. Even more astonishing, the opinion was authored by none other than Justice Amy Coney Barrett herself. The media spun with disbelief. The same justice who had so pointedly challenged Musk had now written the decision that largely vindicated his argument. In the opinion, Barrett wrote, "When existing statutes are applied to fundamentally new technologies, courts must weigh whether such application constitutes legitimate interpretation or unauthorized expansion. In this case, the latter applies." Legal scholars scrambled to unpack the implications. The ruling established a new legal precedent. Regulatory agencies could no longer apply outdated terrestrial statutes to technologies that clearly operated in novel domains, like orbit, artificial intelligence, and potentially even quantum networks. Musk issued a brief public statement. "This is not a victory for me. It is a victory for the principle that laws must evolve with human progress." Within hours, stock prices of major tech infrastructure companies surged. Congressional committees convened emergency meetings to draft modern regulatory frameworks. And regulatory agencies across the U.S. were suddenly under scrutiny. What had started as a courtroom duel had exploded into a judicial shockwave, reshaping not just a case, but the entire future of technological governance. The ruling sent political shockwaves through Washington. Within 48 hours, congressional leaders held emergency sessions. Bipartisan coalitions began drafting what would soon be known as the Technological Modernization and Governance Act, a sweeping legislative framework to regulate emerging technologies without strangling innovation. Lobbyists scrambled to reposition. Some once skeptical of Musk now aligned with his arguments, fearing their industries could face similar legal overreach. News anchors across networks echoed the same sentiment. The Supreme Court just told every federal agency, adapt or get left behind. Meanwhile, the Federal Communications Commission went silent. Internal memos leaked, revealing panic. One executive wrote, "This sets a boundary we never thought the court would draw. Our authority just got slashed overnight." At the Department of Justice, legal teams began reviewing other ongoing cases involving AI ethics, genetic engineering, and autonomous vehicles, all now potentially affected by this landmark ruling. Tech CEOs from Google, Amazon, and Meta issued cautious praise, calling the ruling a new era of adaptive legal oversight. Even critics who had once labeled Musk a reckless disruptor admitted he had changed the game. In private, congressional aides shared whispers that this decision might become a foundational case studied in law schools for decades. One tweet went viral. Musk did not just win a lawsuit. He rewrote the way law sees the future. And as DC reeled from the verdict, the eyes of the nation turned towards Silicon Valley and the man who had just redefined its legal future. The days that followed saw a transformation, not just in legal precedent, but in Elon Musk's public image. Once branded as impulsive, arrogant, even reckless, Musk was now being called something few had predicted, a statesman. News channels replayed clips from the courtroom, his calm tone, the clarity of his arguments, the way he shifted the narrative from billionaire defiance to institutional reform. Even critics on both sides of the aisle were forced to acknowledge his shift. A New York Times columnist wrote, "Elon Musk didn't just win a case. He made an argument for the 21st century legal system, and he made it better than any lawyer could." Suddenly, university law schools extended keynote invitations. Georgetown, Yale, Stanford all wanted him to speak. At Harvard, a new lecture series was announced, Regulation in the Age of Innovation, the Musk-Barrett Exchange. In the tech world, Musk's companies saw a surge in credibility. Startups began citing Starlink v. FCC as a reason to pursue bolder innovation. And surprisingly, Musk did not gloat. He turned down interviews with late-night shows, choosing instead to speak at legal and policy forums, focusing on the future of adaptive regulation. Even Coney Barrett, once his courtroom adversary, reportedly told a clerk he came to play. And he played for the future of the system itself. A man who had once tweeted erratically from his couch now stood center stage in America's most important policy debate. And people were starting to listen, not just to his inventions, but to his vision. What began as an attempted courtroom ambush had become something far greater, a legal turning point, a technological inflection, and a cultural moment. 3 months after the ruling, Congress passed the Space Communications Regulatory Modernization Act, directly inspired by the arguments laid out in the courtroom. For the first time, orbital communication networks had a custom legal framework, not one stretched from 1930s legislation, but one crafted for the technologies of 2030 and beyond. In law schools, students now studied the Barrett-Musk exchange like a modern Marbury versus Madison, an example of how even the sharpest legal minds can evolve when challenged by truth and vision. Justice Barrett herself, once the courtroom's most pointed critic, had authored the majority opinion, reshaping the way courts would assess administrative power in the age of AI, space, and automation. In the tech world, a new precedent had been set, not just in law, but in leadership. Musk's demeanor, once a liability, had matured into a model of public advocacy. His face was no longer just on car commercials and SpaceX rockets. It now appeared on the covers of law journals, headlining conversations about institutional reform. More than 400 million additional people gained internet access via Starlink within 2 years, tangible proof that modernization matters. And behind every click, every satellite beam of data, was the echo of a courtroom where one man stood, not to escape regulation, but to ask a nation to redefine it. It was not just Musk's win. It was a win for law, reason, and the courage to adapt. 1 year after the verdict, a remarkable event stunned both legal and tech communities. Justice Amy Coney Barrett and Elon Musk shared a stage at Georgetown Law School's annual conference on technology and the Constitution. Their joint appearance was not just symbolic. It was a masterclass in what civil disagreement and intellectual evolution can produce. Barrett, ever composed, admitted, "I entered that courtroom concerned about unchecked corporate influence. But I left with a deeper appreciation for how outdated legal tools can be just as dangerous as no rules at all." Musk responded with equal humility. "Justice Barrett's questions forced me to refine my arguments. I realized that identifying gaps is not enough. We must help build what replaces them." Their dialogue drew a standing ovation. But more importantly, it ignited a nationwide legal discussion. If laws are living frameworks, why should we expect static rules to govern dynamic frontiers? Universities launched new regulatory innovation labs. Tech CEOs began collaborating with policymakers, not to fight them, but to co-design forward-looking legislation. And even critics who once mocked Musk's courtroom appearance began referencing it as a model of responsible leadership in tech. The headlines no longer screamed scandal or spectacle. They carried words like framework, adaptation, and shared governance. For the first time in years, America was not debating whether to regulate tech, but how to do it with wisdom, humility, and collaboration. The moment that began with tension had bloomed into a national reckoning in a rare era of unity.